I can concert with him,
Perfect. That'll work.
but yes, I did let me know.
Okay. Just checking. That's like, it's gonna be here about it.
I don't. Steve. Perry.
He did ours up there.
She don't want. Yeah, I'm so upset. My understanding is that they're given methods.
I did.
But you haven't had them because he called Saturday about the voicemail and.
Yeah.
It's been juvenile.
Oh, like, you can see like people like it.
And for good reasons.
So since our last meeting, about 2 weeks ago, here was what was changed. 63, 68, shit, we have this good job. The questions I should ask them. Lots of things, well, you think where else have you changed the people around? And what do you make of moving down to that? It's not just a natural waste. They're actually trying to change this. And it's like it's easy.
Talk like you care. So it's like,
Do you think blah 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 blah? This is the first time I met it. What do you think of salad? This is the same.
I'm probably more spend when it comes to lots about us.
She actually cares.
So, it's not. What? It's not fair about the orders.
Yeah.
Oh.
And just justifying the past and having a choice and people pay up ones. So Marlon might be available last month for stuff. For the month, I mean, I was. Questions. Or maybe it was silence and growth first. That's
No, thanks. No, you can't even have any spot.
Interesting. I'm just constantly sort of like trying to. Jeez. Yes, it is. Action is operation. That's something. I was thinking we got this one really lovely stuff. I don't know what's in the view of that. How big changing. That's another word. I try out some, we go past them, even though the, I don't know, that's a place. It's like right down the street from this, it's not happening. Like, mission. I was trying to go my office yesterday. I was my sister.
I can.
Whose name do you mention?
All right. Thank you. Please be seated. Had the power go off in this room several times today, so hopefully it'll stay on. And the internet go down. See whenever record could be on.
State versus Haining.
We are on record in the Meigs Common Pleas Court in State versus Haining 26 CR 077. For the record, I'm Linda Warner, the Common Pleas Court judge. The parties will please identify themselves as being present, starting with the state.
Yes, Your Honor. James Stanley, Meigs County Prosecuting Attorney here on behalf of the State of Ohio.
with assistant prosecutor Attorney Abigail guilty.
And there would be victim survivors in this case. Were victims notified?
Yes.
Are victims present?
Yes.
And so we don't have to wait on anybody else. Okay. And defense counsel,
Thank you, Your Honor. Britt Wiseman, attorney for Mr. Haining. Mr. Haining is seated to my left.
and your name, sir?
Randy Haining.
And we're here for another pretrial motions hearing. I know that Mr. Wiseman had filed last week a request to extend the motion deadline. I wanted to talk about that rather than just setting a date. Also, I know there are a few more motions pending, some of which I've seen responses on. But I have not thoroughly read one that looks like it might be contested because I think some responses were just recently filed. So you want to talk first about motions and timing on motions?
Yes, Your Honor. I do have a motion to extend, I'll find it, motion to extend the deadline for pretrial motions. The reason for that, I set forth in the motion that I filed was essentially supplemental discovery is just continuing to come through. I received, or at least I know, and I noted in my motion that discovery was file stamped on August 18th and August 21st respectively from the state of Ohio to me. I received in the mail today the materials marked August 18th. So I assume in a few days I'll receive the materials marked August 21st. Also, I think in one of the motions of the responses that the state filed, they noted that there are still some outstanding lab analyses that are still ongoing. So for that reason, because of the continuous influx of supplemental discovery, as well as the fact that there are what appears to be outstanding lab analysis that are ongoing, the results of which neither party, I think, are apprised of at this moment, I'm just asking for some additional time. That's reasonable once the state has noted to the court and or myself that all of the discovery has been received.
Okay, can you address those issues on timing, discovery and what's going on?
Yes, Your Honor. There were, when the search warrant was executed, a number of electronic devices were seized. Those are still being analyzed. The expert report should be in my possession Wednesday. Be able to provide that Wednesday of this week. I don't have any control over the analysis of the digital evidence, but once we receive that, provide that to this counsel as well.
And so that would be what you anticipate the end of all the discovery, pretrial discovery at that point, or no?
That would be my understanding, but I will double check with law enforcement.
Okay. So assuming, and those were typically sent, they're huge, so they're probably sent on portable hard drives, I assume, right? Or, I mean, is it so voluminous you have to be using outside hard drives?
I imagine that data would be, there are numerous cell phones, I believe security camera systems, things like that were seized. So the data when it's downloaded would be quite voluminous.
So assuming you can get that within 10 days, 2 weeks, if he gets it Wednesday, then how much time would you need if that's?
I'm sorry. So the expert report that I'm getting on Wednesday is
Okay, that's not it.
different than that
Okay.
evidence that was seized. That was an analysis of the security video of vehicle driving by a church and private residence.
That's what you're getting Wednesday.
Yes,
Okay, but the other is what you said you have no control over.
correct.
So is there anyone you can contact about that?
I've been in contact with law enforcement already this morning. I'll follow up to see if we have a timeline on that.
Who's doing that analysis?
I believe BCI is doing it, but I contacted our local task force regarding that this morning.
So obviously then if we don't even have that, we can't start talking about deadlines for response.
And I was kind of just wanting to make sure I got this on the radar of the court, make sure I had a filing, and I wasn't necessarily saying I needed a
Certain.
specific date, deadline certain. I just wanted, in generality, just wanted the court to know we're still receiving discovery. Once the state is able to proffer that it all is in, I'm just asking for a reasonable time to take stock of what that data is. If it is data that I need to get to an expert of my own or things of that sort, I don't know what's coming.
Right.
But I'm just asking for some sort of reasonable deadline at that point. So perhaps it's premature, but I just wanted to get it on the court's radar.
Yeah, only, it's not necessarily premature, but it's, I don't have the ability to set a deadline until we have those things come in. So I would just direct counsel to notify the court once everything, you feel like discovery is closed. I mean, I know some things pop up, but then we could put our heads together and maybe put together an agreed deadline for those things. But in the meantime, we do have the case moving forward. So, and we have some dates. I know that before you came in, someone said maybe you wanted some of those hard dates also extended.
Yes,
Okay, and
Um,
we'll talk about
do
that
you-
next.
yes, I do have other motions, but do you want me to?
Well, it's all right,
discuss it?
whichever order you want. I know.
It doesn't matter, it's your
There,
court.
go right ahead. You have something in front of you and I have, yeah,
Okay.
I'm flexible.
I do have a motion for disclosure of Giglio and Brady material that was filed August 14th. I spoke with the state there. I think that there's no objection to that. And the state is going to look, I think, and get me what it deems, required to do so. And they may have already complied with that. So I don't know that anything's outstanding, but I don't think there's any opposition to that motion.
That's correct, Mr. Sanders.
That's correct, and I will double check with law enforcement, regarding that motion, to make sure there's nothing that I'm overlooking that needs to be provided.
Okay,
Another motion, thank you for that. The next motion I had was I filed on August 4th, which was a motion for a more specific bill of particulars. This is probably one that was slightly premature just because, I guess as I conversed with the state prior to going on the record, they, had just not yet actually got me a bill of particulars. But they will be getting me that, is my understanding after speaking with him. So, once I review the bill of particulars, I'll see whether there's a need for this more specific bill of particulars, but we were able to have a good conversation today, I think, about just making sure that defense is specifically apprised as to the exact allegations, factual basis, things of that sort, for each element or each charge, each count contained within the indictment.
not just simply a reinstatement of the indictment language.
Yes, and we talked about the indictment does have timestamps on a few different things, so that it is a little more, specific than a regular indictment might be. Again, we were able to discuss, and I think Mr. Stanley knows what I would be looking for. And if there are problems, I think we can address those without further court involvement.
So I'll just have you renew that if at such time you need to have it renewed. Does that sound reasonable, Mr. Stanley?
Yes, sir. And just from the state's perspective, there was a motion or demand for a bill of particulars. Unusual situation in my office in which the indictments were on my computer as opposed to Terry. So it was just a miscommunication in my office as far as getting that taken care of, but we are working on that today.
Okay, thank you. Next motion?
Next motion I had, Your Honor, I filed August 18th. It's somewhat of I guess I'll call it a trial motion, but essentially it was a motion just limiting demonstrative apparel in the courtroom. And I believe that the state had the chance to file a response to that, which I briefly saw on my way here. It didn't sound like, or from what I was able to read, it didn't appear as though kind of at least the core of my motion didn't appear to be opposed by the state.
And the state's response?
Yes, sir. And prior to defense filing that motion, I did have an opportunity to speak with the victim's parents and to address what I imagine would ultimately eventually become an issue as far as t-shirts and things like that, indicate justice for Ethan or for any other sentiments due to on a previous case that where that was an issue on appeal. And so they both agreed and understood. So in my response, I basically just said that for my part and for the part of people in my office, we would try to ensure compliance with whatever the court's order is related to yes, in court displays of I guess support of the victim, or however you want to phrase it. However the court orders that the state will ensure that there's compliance with that.
Anything else you want to add to that?
I just tried to adjust that, and I think the state can see in the court as well. I tried to draft my motion in a way where it was on both sides. I mean, this is just trying to make sure that no one from our side shows up with justice for, Mr. Haining or anything of that sort, or so it was just more of a trying to make sure the jury isn't influenced in any way outside of what the evidence is presented inside the court.
And that your proposal would be that there'd be a mutual order for all sides involved in the case. Okay. All right, next motion.
The last motion, I believe, unless I missed one, was a motion for a pretrial juror questionnaire. Again, this is probably as we get closer to a trial, but I just wanted to put it on the court's radar. Essentially, the crux of my motion here is that asking the court for the opportunity for both parties to inquire of potential jurors prior to them arriving to court. The reason being that it appears as though this case has garnered significant social media attention. There are several Facebook groups, things of that sort that share a voluminous amount of materials based upon what occurs in this courtroom, what was occurring during the investigation prior to July of this year. And I attached as a defendant's exhibit to my motion some social media posts, some of which were from the Meigs County Sheriff's Office specifically, just showing the court how many shares these were getting. A few of the shares were, over 1,000 just from the Meigs County Sheriff's page. And then when my client and his family were arrested, there was over 2.3 thousand, I think, shares of that social media release from the sheriff. Being from a small community, I just believe, and I laid it out in the motion, I think it would be appropriate to try to inquire of potential jurors before they get here as to whether, just the basic questions we would ask. Have you engaged in any of these posts? I put some questions. Essentially, I'm just trying to get at, should we send out some sort of questionnaire prior to the jurors coming in? And again, that questionnaire, what it looks like, things of that sort, I didn't provide one, but I wanted to open a dialogue with the court to see if the court would deem that appropriate. The state and I could work on what the appropriate questions might be to submit to the court. So again, I'm open. I think it's just for both sides, and would try to maybe address some issues and save us valuable time if and when we get to the point where we are selecting the juror.
And the state, if you had responded to that, I did not read that because I did notice this thing about slogans on shirts, but.
I did. It was brief, just indicating that I don't oppose that and defer the court's judgment as far as how to, I guess, if the court does ultimately agree to do that, how to go about doing that. But I do agree that there's been a lot of media attention of various types. In this case, social media, traditional media, local news, TV, podcasts, documentary and production companies reaching out for public records and such. So it is a case that's garnered a lot of public attention. I've always liked in the past where we had the questionnaires beforehand. I know that's changed in the past year or so. But I would not oppose if at least for this case, we reverted back to that. And Mr. Wiseman and I can touch base as far as developing a potential questionnaire the court wants us to. I can already think of a bunch of questions myself.
Yeah, I would like for you guys to probably start working on that at your leisure. And then I part of it is just frankly the expense and bulk of it all. So what I would probably try to do is just have a link to QR code and a link and an online submission process. And those that can't could print and bring it in a hard copy, because part of it is that, some of our prospective jurors are elderly, and if they, if there's a way for them to not have to fill it out and say, I'm over 75 and I don't want to do this case, that really cuts out a lot of expenses and a lot of delays, because that's the bulk of the types of calls we get, right, ladies? So when we send out, especially with the questionnaires, it became people, get confused and frustrated. So we probably need to brainstorm not only the questions that you would want to have for this particular case, but also the most effective way to disseminate and receive that information without being too burdensome on anyone, if we could. So just want to keep those issues in mind as well. So yeah, I don't have a problem with it, except we just saw the way we were doing it. It may have been as much the way we did it as the questionnaires themselves, because I think our current questionnaire is just four pages, or maybe 4.
Yes.
Yeah, 4 pages. So and certainly for a case like this, you would want to customize it. So yeah, that won't be a problem. Let's all just work together on that.
We'll do so as we get forward or move closer.
Okay, and then
So I believe that's all my motions that I have pending, Your Honor. I was able, just for the record, I would note, providing a update as to discovery. I think I did that earlier, but discovery is ongoing. I provided a few notices to the state. Likewise, the state is providing me discovery, so that process continues. As it relates to that, because that process is continuing, I had the chance to speak with my client prior to going on the record. And I discussed with him the possibility of waiver of speedy trial. Mr. Haining understands that this case is going to take some time as we work through a lot of the data that has been discussed here today. The fact that there are still items being analyzed. All of that contributes to my client's desire today to specifically and intentionally and knowingly waive his right to a speedy trial and set this matter on a trial schedule that is somewhat, I would assume, comparable to the co-defendants in the case, which I did note, just looking at the record, it appears as both of those co-defendants likewise had already previously waived speedy trial.
Okay, so my suggestion would be that we find dates and then look at a waiver of speedy trial form that would conform to those dates. So how long before just a reasonable period of time you think it would be prudent to set a motion hearing, and knowing some of that's out of your control, that the BCI, you're waiting on that? I mean, do you think 1 month, 2 months? I mean, I'd want statuses. I'll tell you, we're gonna have at least some sort of status where we're all face to face every 30 days or so. But as far as setting another motion hearing, what do you think is a reasonable period based on communications?
Yeah, sometime in October. I don't know when I'll get that information, and then Mr. Wiseman has to review that to see what, if any, motions in a file, and then I would need a little bit of time to look at that and determine which witnesses I need here.
Late October, that good time, or
That's fine.
November?
What about October 26th at 1?
Your schedules and see if that looks all right.
Yes.
I'd like to set a status between now and then in case we're not quite ready and we need to move that motion date again, because even if it's just a week or 2 weeks before the October 26th, that'd probably be 3 weeks before, actually, just to see if that's a realistic date as we get closer to it.
What about
End of September, or
what about September the 21st at 2:45?
Yes.
okay for the state as well?
I was,
Okay, then assuming we have motions by the end of October and or going into November, when were you thinking to be really ready for trial both sides? Because we would probably want another statuses and or pre-trials between those dates. But do you think you could be ready for trial by December, or you think you're gonna need? Do you remember how long we continued? They're both in January. So do you want to do something similar?
Yeah, sure.
Okay.
Okay, so let's see here. I have Sarah on January 5th. And then I have Beverly January 25th. So do you want to put Mr. Haney in between them or later in February?
In between's fine.
Okay.
So the 11th. I'm assuming you want to start this on a Monday.
Yes. Oh, yes. Yeah.
Okay. The 11th, or yeah, because the 18th is Martin Luther King Jr. Day.
That work for everyone?
Yeah, sure.
I mean, as a placeholder, that will have Sarah's case done in a week.
Unless, yeah. Obviously, if there's a case going, it will have to be continued, is the only other thing. But yeah, I mean, I realize it's hard to prepare for multiple cases right in a row like that, so.
I mean, this past week we had a trial that was
Yeah,
nowhere near as complicated and it
Yeah.
lasted a week.
yeah. So
We understand. I mean, if things have to get bumped, they do. I mean, just
Well-
it's the nature of it.
you would rather do that and bump it if it becomes necessary than go ahead and maybe putting it on out in February?
I don't care to put it in February. I mean, it's
Well, I mean, he's in jail, so that's it, but
it
real
is what
look,
it is.
yeah. So you're okay with February?
February's fine.
Okay, let's do February then, because I imagine these will be at least 2-week trials.
That's my guess as well.
All right, well, the 15th is President's Day, so you wanna start on February 22nd?
Okay.
At 8 AM?
Okay, so, and I want to make sure we're touching base between obviously October 26th and February 22nd. So let's get a late November, early January, early February dates for status and or hearings should they become necessary. Because there's a lot of things that will be moving parts that your attorney will be talking to everyone about as time passes. And I don't want to put too much time in between and let issues fester. So let's look at a late November hearing date.
What about November 23rd at 1?
That works.
I'm just gonna make that a pretrial slash motion.
Okay, that's fine.
Is there any motions? What about January the 4th at 1? For a pretrial motion hearing?
It's fine.
Early February, you said, what about? You want on the 1st or the 8th of February? Let's do the 8th at 1.
No work for everybody, it looks like.
Yes, sir.
All right, I know we've talked about a lot of different things, but is there anything else or any inquiry from the state or other things that the state wants to make sure we cover?
Nothing from the state.
Okay, key is continuing to communicate, and I know the state and defense council do that regularly, so I want to reassure everyone involved that they do that and they'll continue to do that. Mr. Haining, do you have any questions for the court?
No.
Have you been able to communicate with your attorney regularly and as you felt necessary since the last time you saw me?
Yes.
Has he answered all of your questions?
Yes.
Okay, are you satisfied with your ability to work with your attorney?
Yes.
Is there anything else you want to know about?
Not right this moment.
Okay, thank you. Anything else then from defense counsel?
I just have
Oh,
to
yes.
wait for speedy trial.
Let's go ahead and have him inquire on the record and put those, that trial date in February.
Thank you, Your Honor. Mr. Haney, I'm gonna read this waiver of speedy trial to you, okay? We're putting this on the record. It's entitled State of Ohio versus Randy Haney, waiver of speedy trial, case number 26 CR 077. It states, being fully aware that I have a constitutional and statutory right to a speedy trial with respect to the charges pending against me in this action, I do hereby voluntarily waive and relinquish my right to a speedy trial pursuant to section 2945.71 through 73 of the Ohio Revised Code. I further stipulate and acknowledge that this waiver is executed by me knowingly and voluntarily without threats or promises of any kind. I request and consent to the trial of this cause being continued to, and I've written in February 22nd, 2027 at 8 AM. I read this document in its entirety and there's a place for you to sign. Before you sign, do you have any questions at all about this document? And do you in fact agree to waive speedy trial and up and through the point of your trial, which is to commence February 22nd of 2027?
Yes.
Have you signed that then? Your Honor, for the record, my client is signing this document, the waiver of speedy trial that I just recited, and I will witness the same.
Right, thank you. And then bailiff will collect it. Thank you. Anything else you want to put on the record in this case?
Nothing further for defense, Your Honor. Thank you.
All right, then we'll remand you to the custody of the Meigs County Sheriff. Now, I know we have a couple other final pre-trials, so I need to put those on record with me.
Thumbo, he had asked, Mr. Wiseman's gonna ask for a continuance in that one. I don't know if you want it on the record or not.
Sure, yeah, come up. I see she's here. Come on up.
Here.
State versus Thumbo,
We're on record in the Meigs County Common Pleas Court in State versus Stumbo, 26 CR 077. For the record, I'm Linda Warner, the Common Pleas Court Judge. We will have you fill out your name and address and phone number and email before you leave today. Make sure it's up to date. But if you would state your name.
Elizabeth Stumbo.
Okay, and your attorney is going to identify himself
Thank you, Your Honor. Britt Wiseman, attorney for Ms. Stumbo.
and for the state.
Yes, Your Honor, Abigail Gilkey, Meigs County prosecuting attorney here on behalf of the state.
And we are here for a final pretrial motions hearing date, which is typically the last hearing before a jury trial commences. It is often the point where I hear whether there's an agreement or not, or if we're going to need to buckle down and be fully prepared for a jury trial as scheduled. Before we went on record, there was indication that you may be making a request.
Yes, Your Honor. I was requesting a continuance of today's motions hearing. One of the reasons is I do have discovery in the case. Originally, we set dates very quickly at arraignment because she was incarcerated. The court did order a bond to be posted. She did in fact post that bond. So we're not necessarily under such time constraints as we were previously. I have reviewed the body camera footage, but I just needed some additional time to be able to go back through, file motion to suppress on the OBI. So I just need to be able to, some additional time to do that. I spoke with the state. They had no objection to me having that additional time. So being that she's out, there are no issues. I would ask the court for that opportunity.
State response.
Yes, Your Honor, the state has no position to continuance.
Okay, how much time are you asking for?
I could probably get the motion filed in a couple weeks.
Okay, so if we set this 30 or so, 30 to 40 days out to give, because she is out of jail. So-
She is out, yes. And this is, I think she was just arraigned the beginning of July, so we're still only a month and a half or so into this. Yeah, so whatever the court schedule would allow, but I think I can, like I said, I've watched it, just need to go back and watch it and prepare my motion.
Sure.
What about a motions hearing on September the 21st at 3?
Yes.
And then after that, let's go ahead and set another final pretrial status and jury trial date, giving sufficient time for that motion decision to be made after the hearing on September 21st.
Okay.
I know how October looks, so it might have to be November. For the
What
final,
about November the 2nd at 1?
That's fine.
Then the jury trial date of, what about December the 1st?
That's fine.
we're having issues with this and he's been tied up in another court with Judge Evans, so has not been able to work on that door. So unless you were just beeping it, were you beeping it? That's what it's been doing all day. So I thought I should explain. It's been doing that all day since drug court this morning at 8 a.m. Okay, and I don't know if you were in here though, Ms. Stumbo, that all jury trials start at 8 a.m. So all those times will be on the pretrial statement you'll receive from today. And you understand and
Yes, ma'am.
everything's kind of getting moved out to last longer than it was originally scheduled. And that's okay with you?
Yes, ma'am.
Okay. Did you want to have any other inquiry
No.
or any other things we need to address on the record with Ms. Stumbo?
There you go.
Okay, anything else from the state?
No, Your Honor.
All right, thanks. You're good to go then.
Thank you.
Thank you.
She said I needed to fill out a name and all that. I just.
Yes, Jim,
Yes.
they haven't, you haven't been here, so we haven't been getting those forms filled out. She needs to fill out her name, address, phone number, email form.
So you mentioned, you said.
I'm glad you remembered. Thank you for remembering.
I filled out already.
Fine, you can use that table.
No. You want to worry about the motion?
And we have the Patton case yet?
Yes.
Okay, whenever, have you talked to him yet?
Not yet today.
And has Lewis been drug screened?
Not that anybody's, well, I should know.
I'll you want to go back to the very room.
No, I don't believe so.
Move our next one, Robin. Okay.
Sorry, what was you saying?
This is just, and the second one, this is. Sure, so.
This is what-
Thank you. So, we need to remind Brittany that the next person that's scheduled to do the change of plea will need to be drug screened, assuming she's out of jail. Yeah, I need to ask that.
What's the name on it?
Miss Lewis, is Miss Lewis out of jail, Scott?
She is, I thought she was gonna be here, she's had the treatment,
Okay,
outpatient. No, she's not yet.
okay, so yes, she should be here. If she's not here yet, she should be here shortly.
Okay.
I think she's scheduled to 2:30.
That statement now from.
I take it now. You need me?
Yeah, just. These were filed today. And I told Sarah earlier that
Okay.
I was in there with Judge Evans, that you had stuff today, so they went home. Do you just want me to set them for 9 o'clock in the morning, or do you want me to have them come back?
I mean, if it close by, kind of, I always want to do them the same day if it is a true emergency.
Yeah, I know, we weren't until that opened up with finishing that other thing.
Did you finish it?
Yeah.
You don't, so it's not tomorrow. I wondered logistically how we were gonna manage
Yeah.
tomorrow, so you did get done.
Yeah.
I would prefer them to come back today. If that's impossible, then
So we have Zoom arraignments at 9 in the morning, or 8 in the morning, so we could do 8:30 or 9.
well, we have that 9:59, so
Oh,
yeah,
okay.
it'd probably be 9. I'd rather have them fit them in today,
Okay.
but if not, 9 tomorrow. So,
Okay.
thank you very much.
Yep.
No,
not, so there's I actually heard tonight, I'll try to say. The next one that we have with Wiseman that he's talking about, I had reports that he was at a house that the sheriff's office told me where they was actively using.
okay, so.
So in this case, it isn't like a drug case, but it's.
But he's on standing conditions for free trial, so we need to have Jim. Chandler, yeah, yeah.
I just want to make sure that you wanted him.
Oh, yeah, anytime if you get a call like that, absolutely. Yeah.
Okay.
is, Miss Lewis is, as far as you know, is still planning to do change of plea, and I have the victim impact statement. So, I have read through it. So if you guys want to, so at the time, you won't have to wait for you to do that on the record.
Yeah.
Yeah.
We read it.
Yeah, sure. Yeah.
I know that.
Okay, there you go. I have the original.
You know, dances outdoors not open on Mondays.
What is it?
The gun store in Columbus, I'm really upset.
Vance's?
Dances is
Not open on Mondays? I thought Vance's was always open.
I set one really early this morning. I thought I was gonna go pick up the school before I had to come back.
Little reward for yourself. Yeah.
And they were closed. I was really upset about it.
Which one did you go to?
So I got here an hour early. 2 hours.
Did you go to,
All closed.
oh, I was gonna say there's more than one in Columbus, so,
Yeah, that's full. I looked them up.
yeah.
They're closed.
Huh, how about that?
Um.
I'm gonna step out, just let me know when.
All right, please.
Come on, Grandma.
You're not finding them.
No.
Oh, this isn't good.
Just call it.
My bad. All right. Thank you, Lauren. What, how are you? Oh. Nice. So what that is. So.
So,
Yeah, I don't know. What am I supposed to say nice things on YouTube? So where everybody in the world can hear me talk? Well, that was off the record. Well, you know how it's going worse.
did you get my text on Mr. Patton?
Yeah.
Okay. They're drug screening him now. We've got a trial September 22nd.
Well, you know what, I'm doing back there, so just go ahead and have to leave everything and do that.
Yeah.
I've
I've got four or five at the house, so like I probably could only need to bring 2 today. Yeah. Some of the stuff I still can't open, but. I don't know,
It's in that far, but I also, yeah.
it's in a very weird way that it's all got to us, I think. You probably got it the same way, but it's
All right.
it's very random. There's a few things I can't open, but we'll get there.
You have, I want to give you my cell phone number and Lee Roberts, his mom. Talked to him today. He said that you need his cell phone number. Sure. The other one is that.
I'll write it down here and then I'll hit my phone.
What's 740 707 7057.
You're telling this all over YouTube, just,
Oh, yeah, hold on.
unless you want to write it down for me. So you don't give away somebody's cell number.
Yeah. I'll be respectful.
Okay.
I'll take this.
There you go, yeah, understood.
This is yours, I think.
I was gonna say, if you had a second, I'd be right there and chat with you if you want.
Yeah. Wait, I'm just someone show up for a change, like, yeah, so. I'll poke my head out to double check.
Okay.
Using the radio is on 6. So I requested it, maybe it's on its way.
No, we're not just on that tracking portal. Let you know discovery has been processed and sent, it should be sent discovery through Abby. I'll send James a text about it's called Matrix.
You know, we go to them.
Huh?
You know, we go to them. You know, we do have, we probably aren't going to have it.
Put some,
It looks like we responded on the 13th, so it's probably just coming through.
Okay.
I was supposed to say, I thought I remember her saying she was, like,
Maybe I got it.
needed the file for something. And she was like, I have. And she's-
Yeah, I don't know. It's not in this file, so. Yes.
maybe I can break up next time if this Josie Code lawsuit and we won't have to worry about Matrix because they just won't be showing something soon. I got I filed suit on that in that case.
You know, I first hearing.
I waived service and so they have time to respond to us. Other since they claim. We broke my client's case.
Allegedly,
Oh, no, it's not
that's
alleged.
the first time we get sent.
They broke their face. The question is whether or not,
Great.
there's questions in the case, but that's not one. So. Hey, then we don't do that, and yeah, I gotta make sure you get screened.
Okay.
I'm gonna talk to the lady. I'm not talking to her. And then while she's doing that, I can chat about it.
I told you to take it. I'm still just enjoying. I wrote 3. Yeah, it's not hot, okay. She just doesn't hear, I mean, it's not 3 yet, but. Maybe. Do you have Cleveland, what'd you say?
What organization?
Sure. Yes. How 3 words in 1 minute? Highlight, I haven't.
Oh, nine, nine, nine.
I was, you know, they were very.
I don't know this one.
He's in there, apparently he must have felt for something, but I think it's something, he has the script or something, I'm trying to. Picking that out, that's what I was taking when I walked through.
Right,
So I'll go sit right around him up.
so Mark Daly, stop, shoot. Oh. All right, so, well. Sorry.
That's the up front there. Check. You know where Brett went? Mhm.
Absolutely. I did. Actually, well, people. It wasn't, I'm sorry. Oh. He said you mentioned you saw the fan.
Forward then?
Yeah.
All rise, please.
Thank you. Please be seated. This is Mr. Patton, right?
Yes, you're right.
State versus Patton.
We are on record in the Meigs Common Pleas Court in State versus Patton. Case number 26 CR 029. For the record, I'm Linda Warner, the Common Pleas Court Judge. Please raise your right hand, sir. Do you hereby swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Your name?
Donald Jacob Patton.
Okay, and did you provide your address, phone number, and email on a piece of paper?
Not yet.
Okay.
He just handed me this paper.
Okay, you can do that afterwards. Just make sure you get everything up to date.
Yes. Thank you, Your Honor. Brett Wiseman, attorney for Mr. Patton.
Okay, and for the state?
Yes, Your Honor, Abigail Gilkey, Meigs County Assistant Prosecuting Attorney here on behalf of the state.
Okay, we're here for a final pretrial motions hearing, next thing being the jury trial. And I do appreciate, Mr. Patton, that you were screened. I know there's some information you're trying to get verified about one of the positives on here, and you're gonna have it sent to the court, right?
Yes, ma'am.
Were you able to talk to them?
I tried twice. I was not able to make contact. I will, after this court, if I'm able to, I will contact my soon be legally fiance and have her send a picture of my bottle
That'd be good.
medications.
That shows the dates and the, okay, that would be good. All right, so where are we, Mr. Wiseman, as far as preparation for trial?
Your Honor, we do not have an agreement. I think we're just a little bit far away. Offers have been exchanged between parties. Not quite there yet.
When are we scheduled?
We have a jury trial date, I believe it's September 22nd. So I'll continue to see what we can do to move the ball forward from our perspective. I know the state has to go through a victim in the case, so that we don't have an agreement yet.
Okay, and that is fine, and if you don't, that's fine. Obviously, we have the right, and we'll go through the jury trial process. I would like to set something, some deadlines and at least a status hearing before that trial date, and I do see it is the 22nd. Along with several other cases that I don't know that, looking at them. Are you on Richards? Are you on that too?
Doesn't sound.
Okay. Because we have,
Unless it's a new one.
I know he has like 3 or 4 different cases that are set for jury trial that day too, and I think he might be incarcerated. So that, just for what that's worth, it means you could get bumped because you're not incarcerated. So
Wait, did you say Richards? I think you mean Roberts, and that would be Mr. Wise. Are you looking at 22nd?
yeah, but after that, the one that has Mr. Woodrow Richards has like
Okay,
4 or 5 cases. Well, yeah, I was thinking, I was just talking, okay. Those are,
Then Mr. Roberts would be Mr. Wiseman's client.
right, and he's scheduled that day too.
I think we have an outstanding competency evaluation for him. So that could delay that one possibly.
So you want to leave the date at this point?
Yes, that's fine.
Okay, and we'll just schedule some sort of status, a week or So before that, and of course, 1 week before the jury trial, we'll need to make sure all the exhibits are uploaded by both the state and defense to the case center reviewing. And that proposed jury instructions are submitted.
Yes, Your Honor.
Anything else that we need to make sure we do other than get that date?
No, Your Honor.
Okay, and you guys have been able to talk and communicate regularly? Okay. Okay, the state.
Okay, so the 7th, I have the courthouse is closed for Labor Day, and so I was going to set it for the 14th because Mr. Wiseman has a ton, but it says no prosecutors. Is that true? Cause we have a bunch of here. Like 1, 2, 3, 4, 5, 6, 7, 8.
Oh, yeah. Were you all three gonna be gone?
So if none of you are gonna be here, one of your motion to continue, and the same thing on Tuesday, the following day.
We are all gone on those dates, all with them.
You guys don't schedule it then.
Ugh,
Yeah. Ooh.
yeah, that looks bad.
Yes, it does.
You might have to come on a Friday. Oh. Oh, good VAs on that Friday. Are you all out on September 25th too,
Yes,
and 24th?
yes.
Well, I mean, I could use August 31st, Judge, but that's literally next week.
Right. Unless we could do well, no, they're not that week at all.
Yeah.
So since we don't have Monday, the 7th because of Labor Day, do we already have Mr. Wiseman here on Tuesday, the 8th?
We don't.
Would that be something that we could do? Because then that's 2 weeks before the jury trial, and the following week we can't do it because the prosecutors are out. Or is there a different day that week that might be better for you, Mr. Wiseman?
On the week of the
7th of September.
would. I'll be down in Gallipolis in the morning on the 9th,
Okay.
afternoon of the 9th, if possible.
We could
Yes.
set it at 1.
Yes.
That would work for me.
Okay, runs with that is September 9th, house 1.
Thank you for that.
Yeah, sure. Yeah. We need to do that. So that'll be the next time you come in, Mr. Patton, would be on that date at 1. And then, of course, to make sure at that time that we're fully prepared for the jury trial, that's approximately 2 weeks after that, a little less than 2 weeks after that. So make sure you keep in touch with your attorney and have everything, people, exhibits, such worked out with him so you're ready to go. Do you have any questions? All right, anything else from the state?
No.
Thank you.
Thank you.
Mhm. He's got to fill that out.
Yes.
He's upset. You're gonna go give that to whom?
We have Mr. Daly. We're just gonna keep our dates on him. It's our initial pre-trial, so.
Okay, you don't need him to come up or anything?
No. he
I
comes back
I
here.
see he's here.
I've met with him, nothing special today.
Okay, you keep the dates same, we're good.
Yes, please.
Alright, so I don't know, Judge, if you wanna do your please thing on Lewis or.
Yes, I don't care if we do it in here or if I go to county court and Judge Evans uses his courtroom.
I think my client's here today.
Oh, she's not here yet? Okay,
Oh, so we'll go
Not that
ahead.
I've seen.
okay.
I think
So
I assume she's being brought from Gallia.
Oh,
Around.
well, let me see if she's here. I hear that beating in my. sleep
Oh, I
when
know, that thing, we're gonna have to.
Oh, that was making.
I know, but it's been going off.
Since 8 o'clock.
Yeah, since 8 o'clock, since we were here at the earlier hearings. We're gonna have to figure that out, because it's gonna drive us all batty.
We had to do it once while I was in here and I just.
But
said
it did all, yeah, it
Yeah,
did
that's
all
what we were
morning. We're through drug court, and through the thing with that judge from Texas and everything.
So the plug in that there, by your thing,
Yes,
that bottom, whitish one that's, if you just unplug it, it'll kill it.
the black one.
No, this one.
Oh, that one. Well, I wonder if there's something wrong with that. I mean, if it keeps beeping, probably we'll have you do that.
I'm trying to get it to do it while I'm in here, it's only done at once.
Of course, it won't do it while you're in there. Like
So,
taking your car to the shop. It's not gonna do it while you're here. So do you know if Miss Brown's here? Yet? Did they transport Miss Brown yet?
they brought somebody down, but she was not in uniform. She wasn't in orange, she was
that doesn't-
black, regular clothes.
Well, that would, might be her. Can we find out?
Yeah.
Yeah, if you can find out. Yeah, Miss Lewis ready? Oh, okay, I'll ignore you. Yeah, you just leave that there, Mr. Pat.
Wait, what?
You can just leave the paper there. We'll get it. Thank you. How's that back row? So is there a problem with Lewis?
We're gonna request it, so she has, I can explain it to the better
Okay,
terms.
so the drug screen was fine.
I'm sure.
It was the fear that she would be dirty?
No, I don't think talking about. She's not.
Okay, just still some confusion or a lack of understanding?
Yes, I think that.
Okay, we'll get into the back. You still have to go through the paperwork with her?
I already did once, but I can go through it again.
Okay, I'll get out of the way because it looks like my plea that I was willing to do somewhere else is not gonna happen right away, so you'll have this for me.
Okay.
But you're good to leave, Mr. Are you all right with Mr. Patton leaving?
Yes.
Okay, you can go, sir.
Oh, I am. Yeah, I know that he was trying to get that prescription
Yeah,
photograph sent to someone, but
Would it be, the same, would I be okay to, but try to get that information, please, before reports?
no, get it to our probation department. The fellow that was talking to you, Chandler, that's who you'd give it to. If you need to go back around to get his direct number, you can do that. You know where the probation department is, where you went to screen, just go back there and get his contact information, please.
Thank you, ma'am.
Uh-huh. So we need Andrea in here because Scott's client needs a little more time to work through some questions. How are things on Pomeroy Pike? My son's in love with it. Huh? Yeah, no kidding. Even up at like we all are, it's been awful. You know, our dirt road. Oh, yeah, yeah. We all share locations, my family, all of us, and I often see my son going between where I grew up, where he was largely living, to his girlfriend's house that he's getting married to in October on Rebel Road. So I see him going by your house. It was cuts through Pomeroy Pike to head to Rebel Road. So Miss Lewis needs a little more time. Yeah, we'll go on record, but we'll wait till Scott gets back in there. Paula, how's your mom? Is she living there with you guys, right? Yeah. How old is she now? 81. Yeah, wow. Yeah, we all, you use the parts long enough, things get worn out. The babysitter for our boys lived to be almost 104. And every time if she'd complain about something, I said, well, you realize how old that part is? You know, real. She was okay with it though. She did amazingly well. So. Stayed at home. I mean, she lived at home until she passed. Pretty good. Huh? Oh, did you? Good. Where'd you get yours? Athens? Yes, good. I wear mine all the time, but this morning in drug court, I really noticed that I was having trouble, so I turned them up a notch. I need to go see I want to go to the Carlton girl that's a new audiologist. I know her grandma and stuff, but I need to get an appointment with her. Because I've been wearing mine for a long time. I mean, years, 10+ years. They make a difference, don't they? So I know you couldn't at all. She put her headphones on. So can Terry hear? You can hear okay? You didn't at work or shooting guns or anything hurt most people hurt their hearing by working or shooting here around here. Yeah, well, that's true. Yeah. Yeah. We always wear hearing protections when we shoot. And I wasn't going to shoot. My husband was shooting last night, and I was in a different part of the house out on the porch, reading, and I thought, well, I probably should be wearing. It was clear a different part, that's real close, but then he wanted me to come shoot with him, so I put it protected on anyway. You want to put her on the record and get the new date. And then we'll get out of the way so Judge Evans can. Shelley, is this my copy to keep for the next time? Okay, keep that.
State versus Lewis.
We are on record in the Meigs County Common Pleas Court and State versus Lewis 26 CR 035. For the record, I'm Linda Warner, the Common Pleas Court judge. Please state your name.
Cindy Lewis.
Okay, and your attorney is going to state his name.
Scott Petroff on behalf of Mindy Lewis, seated to my left.
Okay, and for the state.
Yes, Your Honor, Abigail Gilkey, Meigs County Assistant Prosecuting Attorney, here on behalf of this.
And there would be victim or victims in this case. Is that correct?
Yes, Your Honor.
Was the victim notified?
Yes, Your Honor.
Is the victim present? You anticipate the victim being present?
Said she was coming, so.
An issue of the victim impact statement that we talked about. Okay. We are scheduled for a change of plea today and all lined up for that. You are staying at a facility, right? So.
She's currently filled out.
Okay, great. So, but I still want you to fill out the form, just to make sure we have verified addresses each time you come in. But I'm prepared to do a change of plea, but defense counsel indicated that may not be possible today.
Yes, Your Honor, we're asking for a brief continuance in this matter. As I was going through the paperwork with Ms. Lewis, there were a number of questions that she had. And so for her to take some time to consider the answers that I've provided to each of those questions, for her to have a full understanding of what she's planning to, we would ask for a brief continuance. I do have a waiver for either trial. I'm prepared to execute that, gone with that issue with my client as well.
All right. What I'd like to do is schedule change of plea date and a date after that for a jury trial in case we aren't able to do the plea for whatever reason. So we can make sure we've got people subpoenaed and, ready to go. So let's talk about the trial date and work backwards from there. Or for either way, just so we get a change of plea and then a few weeks later, a trial if that change of plea doesn't work. You know what I'm saying?
Yeah. Just trying to look to see when Mr. Petroff's back.
For a trial date.
Oh, I see here September 22nd in the morning. I think we just.
To do the
we were
plea?
talking about that with Mr. Wiseman.
Yeah, that's fine.
Well, that's if none of these trials go, but I don't think that they.
Well, we can make it to change of plea then and later because she's gonna wait. She's not locked up, so.
Okay.
If you want to do-
Sentencing September 22nd at 10:15.
So there, I've got 1, 2. At least 3 set that morning. If it's a busy morning, my calendar shows that I'm here for a motion to suppress on the 21st. That's a less busy day.
Let's look at that.
On the 21st, yeah, but.
That's like today, Mr. Wiseman and you both here.
Yeah.
Whichever day is less.
Which case do you have
I have 3 cases on the 22nd. I already have 1 case here.
Right, your one at 11:30, how long do you anticipate that would take for that motion to suppress? Because if it's a short one, we could maybe fit it in before those.
There's only
trials.
one. So
Well, on the 22nd, 2 out of your 3 cases are this initial pretrial.
And let's do it the 22nd.
Okay. What time?
You wanna do it at 8 or 10:15? Are you wanting to get out of here or something?
Let's do 10:15.
Okay. And then. Can I use 10/6 as a possible jury trial date?
That works.
That'd be the date you put on there, yes, thank you. Your attorney's filling out some paperwork that he's gonna go through with you now.
So we talked about there was speedy trial date. Maybe we can request a trial. We've got a trial set coming up. We'll be able to think about this. The things that we talked about, we're gonna ask to continue the trial date, which was really good. We know that. You have any questions about the speedy trial dates? We talked about it, but
You have to answer out loud too.
so this is being recorded, so you have to answer yes or no. Your question is not just speedy trial rights. Are you okay with signing this waiving your speedy trial rights until your trial date on October 6th?
Wait, but that only means that we don't have, we're not doing it until October 6th or the.
Exactly.
Well, we wouldn't have the trial till October 6th. September 22nd would be the opportunity to do what you were gonna do today on September 22nd, a change of plea. It would only be if for whatever reason that doesn't happen on September 22nd, that the October date would be an opportunity for a jury trial.
That makes sense. So. Yeah. The seller paperwork is for you to take home and review and think about, call me if you have any questions.
Do you have any questions for me, ma'am?
No.
Okay. Then your bond stays the same, your conditions are the same. I'll take that. Anything else from the state or defense counsel?
Nothing from the defense. Thank you.
All right, then I'll get out of the way, and move my keyboards, which I know Judge Evans does not want to use. Let him proceed.
All rise, please.
Are you ready on this now? I'm not telling them ones.
Yes.
You can ask us here. I'm gonna go up and down there and see.
Andrew, I just set these up there for him or?
All right.
Start case.
Fine.
I believe so, that's all I.
Come on over.
Oh, did you
Grab that made over.
No.
Is this the one that is? Oh, sorry. We can hear from this one. Oh, favorite visiting judge. Good, how you doing today?
Oh, doing all right, and you?
I'm out of here, just in time.
Just in time. You saw me coming, didn't
Yes,
you?
sir.
Sit down, sit down. Saw me coming, so he's shagging out of here. How are you folks today?
Judge, how are you?
Oh, tolerably well. Miss Abigail, how are you today? You been busy?
Have been busy this afternoon.
Yeah, you know what they say, busy hands are happy hands.
Because.
Oh, shucks. Jim, I need my calendar book in there.
Yeah, I don't know. I would ask her what you wanted to do because this is gonna be, I don't want this to be left on me. Have to fill out.
Did he hear me? Go get my calendar book, please.
Yes, sir.
Yeah, that's one. Where this says that they're different.
We're not on the record yet, right? Judge, can we discuss something with you real quick?
Sure.
We don't have to go chambers or anything. We previously, our document said that we were going to argue sentencing.
Yes.
Felony 3 fleeing case. Since then, the court's aware, we've stubbed our toe. Ms. Brown has been incarcerated now for a significant number of days. We, I believe, have a joint resolution to present to the court, if the court would accept it, for community control with the special condition that she enter and successfully complete the STAR program.
On the felony 3 case?
Yes, Your Honor. So we did just modify that to see if the court would entertain that as an agreement, though we previously did not have an agreement.
May I share something with you?
Yes, Your Honor.
Somehow or other, I got that idea. I don't know where I got it, because when I had come up here for the sentencing a month ago or whenever it was, that was one of the conditions that her community control was going to be, was STAR. Now, so that somehow or other came to my attention, and I don't know otherwise how it did, unless somebody knew then what they're telling me now.
Well, if that's still a possibility, I think we would jointly recommend that and see if we can. That's on the table.
Okay, well, we'll get through it whenever we can. I don't have to be in Wheelersburg till 6 o'clock this evening, so.
Bad approach, Your Honor.
Sure. I think too. Thank you.
Well,
Okay, are we good to go?
yes, Your Honor.
All right.
State versus Brown.
Okay, we're on the record matters of State of Ohio versus Samantha Brown. We actually have 2 cases, case number 25CR009 and 25CR010. Let the record reflect State of Ohio's before the court with Assistant Meigs County Prosecuting Attorney Abigail Gilkey and State Defense Counsel tables Attorney Brett Wiseman. And Mr. Wiseman, I take it the lady seated next to you then is the defendant Samantha Brown. Is that correct?
Yes, Your Honor.
And it's my understanding these matters have been resolved. Ms. Brown wishes to change a plea this afternoon and then proceed to sentencing. Is that correct?
Yes, Your Honor.
Okay, would someone like to recite for purposes of the record what the underlying plea agreement is?
Yes, Your Honor. And I'll just recite it the way that we typically do, and if there's something you'd like me to change, just.
I'm not here to change your or turn your world upside down, Ms. Gilkey. You go right for it.
Okay, so, the state believes that if this matter were to go to trial, it'd be able to prove beyond a reasonable doubt. In case number 25CR009, count 1, that Samantha Brown on or about the 17th day of January 2025 in the county of Meigs, the state of Ohio, did commit the crime of failure to comply with order or signal of a police officer. In that Samantha Brown operated a motor vehicle so as willfully to elude or flee a police officer after receiving a visible or audible signal from the police officer to bring the person's motor vehicle to a stop. The operation of the motor vehicle by the offender caused a substantial risk of serious physical harm to persons or property in violation of section 2921.331B and 5 of the Ohio Revised Code, being a felony of the 3rd degree. The facts giving rise to this indictment are that on January 17th, 2025, Patrolman Newland spotted a black GMC traveling down West Main Street in Pomeroy in Meigs County. When he contacted Meigs Dispatch to confirm a license plate, the plate came back to a 2018 Jeep. Patrolman Newland then activated his lights and the truck began speeding towards Middleport. The sirens were then activated and the truck continued to speed away, and at one point Another vehicle had to pull off into the AutoZone parking lot to avoid a collision. The GMC then was going towards the Mason Bridge at around 45 to 50 miles per hour. The vehicle then continued straight to the Walmart parking lot where the passenger then jumped out of the vehicle and got on the ground. The defendant, Samantha Brown, was then identified and she slid over to the passenger seat. The vehicle was searched, which revealed things that are not relevant today. The agreement of the parties now is that upon the defendant's guilty plea to that indictment, the state recommend the defendant be sentenced to community control with a special condition that she enter into and successfully complete the STAR program, that there be a class 2 license suspension for 3 years to life, and that she be assessed the cost of this action. And as to case number 25 CR 010, the state believes that if this matter were to go to trial, that it would be able to prove beyond a reasonable doubt. Count 1 of the indictment that Samantha Brown on or about the 26th day of December 2024 in the county of Meigs, state of Ohio, did commit the crime of possession of drugs, and that Samantha Brown did knowingly obtain, possess, or use methamphetamine, a Schedule II controlled substance, in an amount less than the bulk amount, specifically 0.7295 grams, in violation of section 2925.11A and C1A of the Ohio Revised Code, being a felony of the 5th degree. The facts giving rise to this indictment are that on December 26, 2024, Trooper James was dispatched to a 2-vehicle crash with no injuries on State Route 248 in Meigs County. Upon arrival, Trooper James spoke with the driver of one vehicle, being Samantha Brown, who was determined to be at fault. While speaking with her, the trooper identified signs of impairment, and the defendant admitted to taking THC edibles. Field sobriety tests were then administered, and the defendant was placed under arrest. Her vehicle was also bearing a license plate that belonged to another vehicle, and her license was suspended. An inventory search of the vehicle was then completed, which revealed a container on the passenger side floorboard. The container had a smaller container with a black lid, and inside the smaller container was a crystal-like substance consistent with the look of methamphetamines. The substance was then sent off for testing and did come back positive as methamphetamine in the amount of 0.7295 grams. So the agreement of the parties as to this case number is that upon defendant's guilty plea to the indictment, the state recommend that the defendant be sentenced to community control, and as a special condition of her community control should be evaluated for drugs and alcohol and successfully complete any treatment, and that should be ordered to pay $35 restitution to the Highway Patrol lab as authorized under Revised Code 2925.511 to cost incurred in having tests performed under Revised Code 2925.51 on the substance that is the basis of this conviction, and that the defendant would agree to be assessed the cost of this action as well. Thank you.
Okay, thank you. Mr. Wiseman, is that your understanding of the underlying plea agreement?
Yes, Your Honor.
Okay. Ms. Brown, were you able to hear and understand what Ms. Gilkey indicated the underlying plea agreement is in this case, and Mr. Wiseman has confirmed? Yes, what? Okay. Do you have any questions about it? Is that your agreement?
Yeah.
All right. Now, Ms. Brown, you and I are going to need to talk with each other here this afternoon for a little while. So if anything I say needs to be repeated, you're the one's going to have to tell me that it needs to be repeated, okay? Otherwise, I'm not going to know. If you should have a question, I'd ask that you first direct it to Mr. Wiseman. If it's still not resolved, then he may further direct it to the court. So we need verbal responses. And you're doing quite well so far. So before we get started, if you would, please raise your right hand and be sworn. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in the matters before the court at this time?
Yes.
Okay, thank you. And for purpose of the record, you are Samantha Brown. Is that correct? Now, Ms. Brown, do you understand that you're not required to plead guilty and that you may cause the state of Ohio to prove these cases by proof beyond a reasonable doubt, even though you may feel you have no rational defense to them?
Yes.
And do you understand that the penalties that we're talking about in each of these cases, in the 09 case, you're looking at a 3rd-degree felony. And so what you're looking at is a possible term of incarceration in a state penal facility ranging from a term of 9, 12, 18, 24, 30, or 36 months, up to a maximum fine of $10,000 and up to 2 years of post-release control, and a driver's license suspension, which I understand is mandatory from a minimum of 3 years up to life. Is that correct?
Yes, Your Honor.
Thank you. And as it relates to the 10 case, 25 CR 10, possession of drugs in violation of section 2925.11A of the Ohio Revised Code. This is a felony of the 5th degree. Carries with it a possible term of incarceration ranging from a period of 6 to 12 months, up to a $2,500 fine, period of post-release control of up to 2 years, and a license suspension of up to 5 years. Now, I mentioned post-release control, so let me describe to you what that is. Post-release control is a creature of the Ohio Adult Parole Authority. I commonly refer to it as prison probation. If you should go to prison and then be released, then that agency, not this court, may send you back to prison for up to 9 months, and for repeated violations, then they may send you back to prison for a term not exceeding 50% of the original time as ordered by this court. There is, however, somewhat of an exception to that, and that is this. If while out on post-release control, you should commit another felony, it makes no difference whether it's here in Meigs County or some other county, then that court exercising jurisdiction over that new felony may not only send you to prison for the commission of that new felony, but they may add to that sentence, whatever it might be, the balance of time remaining on post-release control or 12 months, whichever is greater. Now, I know I said a lot there, but my question to you is, were you able to hear and understand all that? You have any questions about it? All right, thank you. Now, Ms. Gilkey has already recited the elements of these particular offenses for purpose of the record in her dissertation there earlier. Mr. Wiseman, would you agree that those are the particular elements of these two separate offenses that the state of Ohio would need to prove by proof beyond a reasonable doubt if these cases were to go forward?
Yes, sir.
Okay, thank you. So, Ms. Brown, I need to ask you, number one, do you understand the nature of these charges against you? And number two, do you understand the elements of each of these charges that the state of Ohio would need to prove by proof beyond a reasonable doubt if these cases were to go forward? Do you also understand that, do you understand the penalty provisions that we've been talking about? Have any questions about any of that? Okay. Now, Mr. Wiseman, have you fully investigated the facts and the law and determined whether there exists any questions of the admissibility of any claimed admissions, confessions, or other evidence under federal and state law, and advised Ms. Brown concerning those?
Yes, sir.
And have you also informed her of the elements of each of these offenses, which it's anticipated she's going to plead guilty to this afternoon, together with all relevant defenses which may be available to her, together with all of her constitutional rights, both state and federal?
Yes, sir.
Now, Ms. Brown, do you understand that you have a constitutional privilege against self-incrimination, meaning that you may not be made or compelled to testify against yourself? And with a full understanding that anything you say may be used against you, are you willing to waive that privilege against self-incrimination and to tell the truth concerning these charges? Now, you've heard the questions that I've just asked Mr. Wiseman. Do you personally acknowledge that he has so informed and advised you?
Yes.
And are you satisfied with the services he has performed for you in these cases?
Yes.
Now, Mr. Wiseman, through your representation of Ms. Brown in your investigation of these matters, in your opinion, is she eligible for community control?
Yes, sir.
Now, Ms. Brown, before I can accept a plea of guilty, I need to advise you of your rights and ask you certain questions to determine if your plea is being made voluntarily, meaning of your own free will, and also that it's being made knowingly and intelligently, meaning that you understand what's happening here this afternoon. So, except for the underlying plea agreement, which has already been stated for purpose of the record, have there been any threats or promises made to you to get you to change your plea? And have you had adequate time to spend with Mr. Wiseman and to seek his guidance and counsel in these matters? Are you currently under any mental or physical condition that would render you unable to understand what's happening here this afternoon? Are you currently under the influence of alcohol or drugs of abuse that would render you unable to understand what's happening here this afternoon? How old are you, Miss Brown? And how far through school did you get?
I was in college for a few years.
Okay, so you've got high school education plus a few years of college. Okay. Was there any particular curriculum that you were following in college? I mean, in pursuit of a baccalaureate degree or an associate degree, or You're just kind of floating around in there trying to find yourself. Okay. Okay, okay. Do you have any special skills or vocational training that you've been able to acquire either through work experience or education? Okay. Now, Ms. Brown, we've been talking about this charge in the language of the statute, or in other words, legal terms. Are there any uncommon or unfamiliar terms there that you need further defined? You understand that upon a plea of guilty, then the court may sentence you immediately to those statutory penalties that we've been talking about? You also understanding by entering a plea of guilty that you'll be giving up certain rights? And I need to touch base with you concerning those, make sure you understand those. Number one, do you understand that you'll be giving up the right to a speedy public jury trial? Do you understand you'll be giving up the right to confront any witnesses against you that the state of Ohio might bring in here, and the right to cross-examine those witnesses from the witness stand? You understand you'll be giving up the right to have compulsory process or the use of subpoena power through court order to bring folks in here to testify on your behalf. You understand you'll be giving up the right to require the state of Ohio prove these cases by proof beyond a reasonable doubt. And you understand you'll be giving up the right to testify or to remain silent, whichever you may choose. Have any questions about any of that? I may have asked you this, but let me ask you again. Do you agree with the statement of Ms. Gilkey that the state of Ohio would be able to prove each of these cases by proof beyond a reasonable doubt? Do you agree with that statement that they would be able to prove these charges against you?
Yes.
Thank you. And do you understand that a plea of guilty is a complete admission on your part that you did in fact commit these offenses? You also understand that a plea of guilty is a complete waiver of all the rights that we've been talking about. Do you further understand the court is not required to accept your guilty plea in these matters? And even if the court does accept your guilty plea, you understand the court is not required to go along with the underlying plea agreement as it relates to penalty or punishment, but that whatever penalty or punishment you receive will be left strictly up to the discretion of the court. You understand that a plea of guilty bars or waives any rights to raise possible defenses to these matters. Have any questions about any of that? Ms. Brown, are you in fact guilty of these charges against you? Has everything you've told me been of your own free will and accord? Is it your desire then at this time to withdraw your previous plea of not guilty and now enter a plea of guilty to these charges? And is that in fact what you do? All right, thank you. With that, then the court is going to accept your pleas of guilty to each of these charges, find that the pleas have been made voluntarily, knowingly, and intelligently. And with that, we need to go over some documents that have been presented to me here. The first of which in each of these cases is entitled Waiver of Jury Trial. I believe that's the first one I'm going to go over with. Get the papers separated here. Mr. Wiseman, looks like you need to sign this one form here.
I will do so. Apologize.
That's okay. I state I, Samantha Brown, defendant in the above case, being now in open court, hereby voluntarily waive and relinquish my right to a trial by jury. Further, I acknowledge that all explanations required by the Ohio Rules of Criminal Procedure 11C have been explained to me, and I fully understand that a plea of guilty gives up those rights. And I'm looking at what appears to be a signature on a line under which is typed the word defendant. And so I need to ask you, is this in fact your signature?
Yes.
Okay, well, I had to ask. This is your signature. And did you sign this document voluntarily and with full knowledge of what you were doing? Is there anything in this document that you do not understand? All right. With that, then the court is going to accept these documents. Well, the other document we need to talk about is plea agreement. Here, Mr. Weissman, you and Mr. Brown can sign those together on different lines, of course. Brown, as it relates to the guilty plea document, I'm looking at what appears to be a similar signature on a line under which is typed the word defendant. So I need to ask for purposes of this document, is that in fact your signature?
Yes,
And did you sign this document voluntarily and with full knowledge of what you're doing?
yes.
Are you a U.S. citizen?
Yes.
Is there anything in this document that you do not understand? All right, thank you. With that, then the court is going to accept these documents and find that Ms. Brown has executed them voluntarily, knowingly, and intelligently. And with that, then the court is going to sign the judgment entry of finding of guilty. And with that, I understand that we wish to proceed to sentencing at this time. Is that correct?
We do, Your Honor, and on behalf of the defendant, we would waive PSI in this matter, would elect to proceed immediately to sentencing. And we would waive the state reciting what the agreement of the parties is again, unless obviously, of course, the court would want the state to do so.
I don't think that's, did you want to do that again, Ms. Gilpin?
No, Your Honor, not unless you'd like me to do it, but the state would also waive PSI and would like to also listen.
You'd be tickled to death to do it if I wanted you to, though,
I
right?
would do it.
All right, I appreciate that. All right, is there any reason we should not proceed then to disposition of these matters?
No, Your Honor.
All right, well, the court finds that Ms. Brown has entered a plea of guilty in case number 25 CR9 to a charge of failure to comply with the order or signal of a police officer. As indicated earlier, this is in violation of section 2921.331B of the Ohio Revised Code. Felony of the third degree, carrying with it a possible term of incarceration in a state penal facility ranging from a term of 9, 12, 18, 24, 30, or 36 months, up to a maximum fine of $10,000, a period of post-release control of up to 2 years, and a mandatory operator's license suspension of 3 years to life. As to case number 25 CR10, she has entered a plea of guilty to a charge of possession of drugs in violation of section 2925.11A of the Ohio Revised Code. Felony of the fifth degree, carrying with it a possible term of incarceration in a state penal facility ranging from a term of 6 to 12 months, up to a $2,500 fine, up to 2 years of post-release control, and a license suspension of up to 5 years. Do we have, I don't know that this is a victim type offense, either one of these, but do we have someone that would like to speak for a victim? Do we have a victim in the escape, or not the escape, but the fleeing and eluding?
No, Your Honor.
All right. Ms. Brown, pursuant to Criminal Rule 32, you have an opportunity at this time to address the court concerning information and mitigation of penalty or punishment. Mr. Wiseman, on your behalf, has the same opportunity, and Ms. Gilkey, on behalf of the state of Ohio, has an opportunity to speak on behalf of the state of Ohio. So I would ask you, do you wish to address the court at this time? No? Okay. Mr. Wiseman?
Just briefly, Your Honor, I would ask the court to accept the agreement that the parties have fashioned in this case. Ms. Brown does have 2 children who I know she's wanting to prove to them as well as herself that she can remain clean and sober. She's been incarcerated now since the court obviously did not allow her to post bond. She's looks the best that I've seen her in my representation of her. She has no prior felony convictions. She has a low ORAS score, again, no criminal history. She talked to the court a little bit about her educational background. She actually is the one who asked me for the opportunity to go to STAR. I wanted to see if I could get the state on board with that. I appreciate them joining with us in the recommendation. I think STAR would bridge the gap between jail and getting her between jail and just releasing her out into society. She can get the tools that are necessary to try to help her create a better life for herself, for her children, give her some of those vocational training that the court inquired of her about, so that when she is released, she has those tools necessary to make a good living and get things back on track. She also has a good support system. The individuals and adults that are in the back of the courtroom today, I believe, are here on Ms. Brown's behalf. So once she goes to STAR and then is released, hopefully on community control, if the court accepts the agreement, I think she can and will be successful. So I would ask the court to allow her that opportunity. Thank you.
Well, I hope she would do well. Do we know if there is a bed date for Star? Anybody inquired about that?
Thursday.
They'll come and pick her up, right? Okay,
And the only other thing that I failed to mention, Your Honor, and I apologize, is I would ask the court to consider a 3-year license suspension. That's still a significant amount of time. I know that's mandatory. Ms. Brown has no prior felony convictions, as I noted. Once she does get released from STAR and starts to work towards some of those goals, having a license is going to be important and critical to her to getting employment. And obviously living in a rural community, public transportation is somewhat limited. So I would ask the court to consider that minimum 3-year license suspension. Thank you.
okay, thank you. And Ms. Gilkey, do you wish to address the court at this time?
No, Your Honor, the state would just ask the court again to go along with the agreement with parties.
Okay, thank you. Any reason we should not further proceed now, folks?
No, Your Honor.
Okay, well, of course, the purposes and principles of sentencing are guided to the courts through section 2929.11 of the Ohio Revised Code, and their subsequent sections as promulgated by the Ohio State Legislature. The overriding purpose is to punish the offender and protect the public from future crime by the offender and others, always using the minimum sanctions that the court determines the purposes and principles, without imposing an unnecessary burden on state or local government resources. Always considering the need for incapacitation, deterrence, rehabilitation, and restitution, making sure all the while that the sentence is commensurate with and not demeaning to the seriousness of the offender's conduct and its impact on the victim, if any, and also consistent with sentences for similar crimes by similar offenders, making sure all the while that the sentence is not based on the offender's race, ethnic background, gender, or religion. Well, the court has reviewed the record in this matter, as well as the plea agreement that was made by and between the parties, and the comments that were made here today. So, and the court has also weighed the seriousness and recidivism factors under section 2929.12 of the Ohio Revised Code. The court finds that we have one felony of the 3rd degree, and that's in case number 25 CR 9. We have one felony of the 5th degree, which is in case number 25 CR 10. I probably should have asked, is it okay to do these together instead of doing the sentencing separately?
Yes, Your Honor. Defense would stipulate that that is appropriate given the situation. Yes.
All right, thank you.
Yes, Your Honor.
All right, thank you. Court finds after weighing the seriousness and recidivism factors that prison is not consistent with the purposes and principles of sentencing. Also, the offender is amenable to an available community sanction. So, having said all that, Ms. Brown, it's going to be the order and judgment of the court that you be sentenced to a term of community control for 36 months. You're going to be subject to the basic terms of community control, save and except the STAR facility that we're going to ask you to attend. You do need to report to your community control officer as ordered. Going to need to pay the supervisory fee that's associated with community control. You need to do that starting the first Monday after the first month after you are released from STAR. Once you're released from STAR, you need to report to your community control officer. within a week, okay? And in conjunction with that, we've been talking about STAR, you are to successfully complete any counseling that's ordered. And so in this case, it's going to be STAR. You need to register with the employment office within 2 weeks following your release from STAR. You need to verify that with your community control officer. If you get a job, then you need to verify that with your community control officer. If that registration runs out, then you need to re-register and verify that with your community control officer. The idea being we want you to either be working or seeking. It's really just that simple. We are going to suspend your license for a period of 3 years. And that suspension will start now, which will give her about 5-6 months or something. Already served on that for the time she gets out of STAR. Ms. Brown, you're going to be ordered to pay the court costs of these proceedings for which judgment is rendered and execution may issue. You're advised pursuant to section 4920 or 29.47.23 of the Ohio Revised Code that if you fail to pay that judgment for costs, supervisory fees, or the like, or if you fail to make timely payments toward that judgment under a payment schedule approved by the court, then the court may order you to perform community service in an amount deemed appropriate by the court until the judgment is paid or until the court is satisfied that you're in compliance with an approved payment schedule. You're further advised that if the court does order you to perform that community service, then you will receive credit upon the judgment at a specified hourly credit rate of each hour community service performed, which shall not be less than the federal minimum wage rate. And for each hour of community service performed, that will reduce the judgment by that amount. If you haven't already done so, you are ordered to pay the indigency fund within 10 months, the Rotary Reparations Fund within 10 months, bail bond surcharge fee within 10 months, and your drug test, as was mentioned in the plea agreement to the Ohio State Patrol Lab, within 10 months. Now, I need to tell you what happens. Well, you also need to pay the supervisory fee, and we already talked about that. That was what, the first month after the first Monday after the first month that you're released. Need to talk to you now about what happens if you come back here and you've stubbed your toe and you've goofed up and you violated the terms and conditions of your community control. Court has 3 options. Number 1, the court may extend the period of your community control. You could have been sentenced to 5 years community control. As it is, you've been sentenced to 3 years of community control. So the court has 2 more years there at its disposal. The second option the court has is to make your community control sanctions more restrictive. You may think they're somewhat restrictive now, but I assure you they may be made more restrictive. And the third option the court has is to send you to prison. We've already found out that in case number 25 Sierra 9, you could be sentenced to prison for a term ranging from 9, 12, 18, 24, 30, or 36 months. In case number 25 CR 10, we've already determined you could be sent to prison for a term of 6 to 12 months. So now the court needs to advise you of what you will be sent to prison for if you should come back here and be found guilty violating the terms and conditions of your community control. I don't mean to lecture you, Ms. Brown. I just want you to understand the gravity of the situation you find yourself in here and how we're still trying to help you by going to STAR, letting you be on community control. What I'm saying basically is it's all up to you. Right now at this time, none of us would be right here in this courtroom if it weren't for you. So we're all here for you, okay? So if you should come back here and be found guilty violating the terms and conditions of your community control, the court will consider that you have made an informed decision that you want to go to prison. And I'm here to tell you that if I'm sitting here, you will go to prison for 11 months. In case number 25 CR 10, excuse me, 9. Well, that's not right. It's going to be 11 months on the felony 5, and it's going to be 30 months on the felony 3. And if at all possible, they will be scheduled to be sentenced consecutively, meaning one after the other. It's that serious. And again, I don't mean to scare you, don't mean to lecture you. I just want you to understand, I appreciate the situation you find yourself in and what everybody here has done for you. We will give you credit for time served. I have no idea what the time that is, but whatever it is, it will be determined, and we will give you that credit. Now, Ms. Brown, a little bit ago when you were here and we went through your plea colloquy, there were a number of things that we talked about, but one of the things I asked you is you acknowledged that you waived certain rights of appeal. Do you acknowledge now that you have waived certain rights of appeal in these cases?
Yeah.
Thank you. Now, the other thing we talked about was post-release control. We just talked about that a little bit ago. Would you like for me to tell you about that again? Here goes. All right. Post-release control is a creature of the Ohio Adult Parole Authority. I commonly refer to it as prison probation. If you should go to prison and then be released, then that agency may place you on post-release control, and in these 2 cases, up to a period of 2 years. Now, if all that should happen, and you should then violate the terms and conditions of your post-release control, then that agency, not this court, may send you back to prison for up to 9 months, and for repeated violations for a term not to exceed 50% of the original term as ordered by this court. There is, however, somewhat of an exception, and that is this. If while out on post-release control, you should commit another felony, it makes no difference whether it's here in Meigs County or some other county, then that court exercising jurisdiction over that new felony may not only send you to prison for the commission of that new felony, but then may add to that sentence whatever the time remaining is on post-release control, or 12 months, whichever is greater, to be ordered to be served consecutively, meaning one after the other. Now, again, I know I told you a lot there, said a lot. Any questions about any of that?
No.
You understand all that?
Yeah.
Would you like for me to repeat it again? Okay, thank you. Court would also order any finding herein that may be considered to be in conflict with a case of State versus Foster's deemed by this court to be advisory. Also order any additional periods of time imposed by another court or by the parole board or violations in this case filed on post-release control are a part of the sentence in this case. And a part of the community control, as we've already talked about, but more specifically, it will be the order and judgment of the court that you successfully complete the STAR program. I understand there's a bed waiting for you. The pickup will be Thursday. What do Jim leave me?
He's over on that side, Judge, behind the TV.
Oh, he's moved around on me.
Just hiding this.
Yeah. One last thing, Ms. Brown, you do have the right to have notice of appeal timely filed on your behalf in this matter. If you're unable to pay the cost of an appeal, then you have the right to appeal without payment. If you're unable to obtain counsel for an appeal, then counsel will be appointed without cost. And if you're unable to pay cost of documents necessary for an appeal, then those documents will be provided without cost. Okay? Have we covered it all, Mr.
I
Wiseman?
believe so, Your Honor. Thank you.
Ms. Gilkey? Anything else we need to take care of?
There, Your Honor.
Take care of? Okay. If there's nothing further, then we'll stand adjourned. Thank you very much. I believe these are the ones that need to go to Andrea. Andrea, you may still need to
Okay.
fill out something on this back page. I have signed it.
Okay, all right, I'll look at it, Judge.
Now, you need me to sign an entry so you can get her situated by Thursday.
Abby is on it. She did a handwritten one.
All right, Abigail. She's on top of it. Okay. So those will go your way. All of this goes back my way.
Yeah, it's, that's one that we did. I'm sure if it's not Brandy, it'll be fine.
Oh, here, I forgot to put that in that mess. Just
Oh,
put that
I'll
right.
take that. I need that. Are these the signed copies?
Or do you need this?
The signed copies, yeah, thank you, sir.
I don't know why, but I ended up with 3 copies. I think it's because we had 3 different times that we were gonna do that.
That might be true.
If she,
Could be true.
if she goes to regional, they'll pick her up there.
You saw my text, I know
Yeah.
that's between probation and the SO, doing the paperwork.
Well, stars at the bottom of the hill for regional.
Oh, okay, well then, yeah, probably. I wouldn't see why not,
And they're like
then.
3 miles apart.
Yeah.
And if you walk over the hill or.
Okay, formal sentencing entry will follow.
Yeah, what is that, Judge?
I have no clue.
Not, no. If that entry does not work, I will have to make a trip to Gallia to see you for you to sign these entries for me.
I tell you what, though, we anticipated that I would be up here tomorrow on that debacle with Brickles and so forth. So,
Okay.
I mean, I could make a side trip up here tomorrow.
I'll do that.
I
I,
can do that. I can do it easier than you can take time off from your work to do.
well, I'm just gonna be like, I gotta run to Gallipolis, I'll be back. They're gonna
Should we
pay.
going all day?
Well, we'll see. If this doesn't work, I'll get a hold of you and we'll plan something, but hopefully this works.
You know, it's not gonna work until Thursday comes around.
Right, I know, but once Brandy reads this of the SO, if she thinks it won't be enough, I will get the
Well,
entry
just let me
done.
know.
I will. I
Let me
will.
know. Yeah, I'm on, headed to Wheelersburg by way of Gallipolis. I think I've got everything I can.
We got the nicest day so far, and we're all in here till 4.
I know, I caught that. The state doesn't have to recite it if you don't tell them to.
We do, actually, Coach Margaret in Cal Police like has me do that or ask us to do that, like, so that's what we do in every case now. Especially if it's usually if it's a prison sentence where you're going just immediately to sentencing, she doesn't ever allow you to waive a PSI. So if it's community controlled, then it's a whole different day and they'll have to recite it again, but if it's going immediately to. prison, We just say, we just say, we don't wish for the agreement to be recited again. It
Wish to be here any longer than we need to be.
saves a minute, I don't know how long it actually saves, but
A minute is a minute.
yeah, they add
On
up,
days like today.
they do. We made it through though.
Yes. All right, get your water if you want, but we.
I will, thank you.
You're welcome.
So it's good to hear.
Oh.
Yeah, all right, this you have to be, you right. Participation in the recovery program, like the local.
Yeah. And honestly, was with work at MSR, they'll ask her like what her goals are afterwards, the after treatment. A lot of times some of them will go into a treatment facility, like rather than one inpatient place, if it's not more expensive, they wanna go home. I don't know what really the situations like, things like that, so. Right.
But she'll have a place to live when she comes out.
Yeah.
I mean, how they work for her.
Okay.
Yeah,
Yeah.
well, yeah, it was listed before where she was pregnant.
Is I?
No, just talk down.
Okay.
See, everything's there.
That's where.
That's nothing.
Oh, okay.
That's where we started out.
I started out,
Yeah, it was a house. And
Yeah.
Our woman lived there. It's had all the people there. She was very relaxed. My case was there for a little bit, but she just tore the place up, so we've been kind of fixing it up. Cause I know she almost, she's got trapped,
Right.
she can't have it, not for 3 years, so,
Yeah.
well. Yeah, but, that's the other part, so, right, she'll just try, I said. You better listen, you better listen,
She's got never read.
yeah, she better listen, because she gets caught again. Because she said she wants me to go get that stuff off Bedwood, because she said it's stuff up there, long or at a thing. And so we got my truck, and I said, I ain't driving that one. You know, I think, you know, I'm not gonna get caught. Cause it's in registration. Yeah. You get it because she hasn't paid for it. And they haven't ever come after, so it's kind of limbo.
Yeah.
Well, there's a way I could get it, I could just go, well. It landed on my property for so long, I just like to get, I always thought it was like big process, but. But I want to do it, but for 3 years.
Yeah. But she definitely, you know, she doesn't have, if she wants to go there, and she's saying she'll call, even if she does come home, we can always try and recommend some sort of an outpatient.
Oh, I'm sure there's a lot of things, I think, well, yeah, she's on the right track.
This, you know, he's got a 15 floor house, so
Yeah.
I look for contact information for that. I don't know if she's got. Okay, I'll just do another copy. I got another copy and stuff.
She said she hadn't got it.
Okay, they were dicey about whether they would pass. One person said no, and the other person said, well, we can make it work. And or maybe they were just told them to give it to her the wrong way.
I don't know, she said she would, but. I'm not the deal there. We got some that she wrote.